Yes.
May it please your lordships. I appear with my learned friend Miss Tetiana Nestorchuk for the appellants, my learned friend Mr. Charles Hollander, Queen's Counsel, Mr. Samar Abbas Kazmi, Mr. James Bradford appear for the respondent. Lords, this is our appeal against paragraph 4 of the order of the learned deputy judge, by which he ordered a case management stay of this action on the terms as set out in that paragraph. And Lords, in view of how the judge expressed himself in the last section of his judgment on the stay, in which he relied on his earlier conclusions as spread about in various other sections of the judgment, we produced on a single sheet of paper for ourselves, but we think it may be of assistance also to the court, a roadmap, as it were, of the judge's reasoning, consisting of relevant quotations from the judgment with paragraph number references. And we've provided a copy already to our learned friends, and I've also had a copy placed before each of your lordships. I hope that will be useful. My lords, this reasoning of the judge, which is encapsulated on that sheet of paper, is challenged by us directly in ground 4 of our grounds of appeal. And we propose to start with ground 4, because if we can persuade you that the judge was wrong in his reasons for the stay, then it follows that irrespective of the other grounds, paragraph 4 of the order must be set aside. And of course, if we succeed in persuading your lordships in relation to paragraph 4, then we also appeal against the no orders to costs in paragraph 5. My lords, having addressed your lordships on ground 4, we will then make our submissions in the following order. Ground 6, terms of the stay, and then grounds 1, 2, and 3, taking grounds 2 and 3 together. We don't propose to address you orally in relation to grounds 5, simply because we respectfully believe that our written argument speaks for itself. And with a fair wind, I would hope to complete our submissions by no later than the short adjournment. I've seen that the appeal is down for a day and a half, although on a court website it said 6 hours, but I'm working on the basis of 7 hours, on the basis that your lordships will rise at 4 this afternoon. And on that basis, if that's correct, I've agreed with my learned friend Mr. Hollander that I will have slightly more, if I need it, and I hope I won't, slightly more than 3.5 hours, and he will, to include the reply.
Well, shall we see how we go? It's our general feeling that the estimate that was given is lavish, and that we'd like to keep alight the flame of the case finishing within the day. I don't mean before the end of the day, but if we can finish it by the end of the day, we'll do so.
I think it was my estimate, actually, so I take responsibility, but I did raise an eyebrow to myself when I came back to the case and saw it.
All right. And don't worry about us finishing at 4 o'clock. I wish we did, but you can assume that we'll sit until 4:30 unless
well, that's very kind.
Anything else happens.
Also,
all right.
Let me dive in then to ground 4. As our document indicates, the judge was of the view that the impediment by which the respondent was hamstrung was that it was a neutral party. The corresponding position was that he took the view that the appropriate respondent to the claims was the OPJ, because there was no prospect of the OPJ ever coming before the English court, the claim lacked utility. My lords, the proposition that the respondent was to be regarded as neutral, and the corresponding position that the OPJ was to be regarded as the real adversary is, with respect, illogical and inconsistent with the judge's other correct findings in the case, and indeed his evidence. Lords, as to inconsistency with his own findings, we make in paragraph 38 of our skeleton 5 points, which we'd supplement orally briefly as follows. First of all, the judge's analysis that the OPJ is the real adversary of an appropriate respondent to the claims is wrong, because the appellants have no cause of action against it, nor did they ever suggest it did. It wasn't a contracting party, and of course all the claims derive from the 2 contracts between various of the appellants and the respondent. And of course your lordships will have seen the declarations track the express terms of those contracts or consequential on them, as the judge held at paragraph 84, declarations concerning the defendant's entry into commercial transactions with the claimants. My lords, those claims were, again as the judge remarked in paragraph 162 of the judgment, juridically unremarkable, and he rightly noted at 152 that the claim wasn't for any declarations directly as to criminality, and any criminal proceedings will take place in another jurisdiction and under another law. And none of the declarations at 159, he held, would involve any assertion as to what does or doesn't amount to criminality as a matter of the law of the Vatican State. And no doubt for that reason, he recognised in paragraph 178 of the judgment that there was no reality to the suggestion that the OPJ ought to join the English proceedings. Quite. So there was nothing adventitious, or almost adventitious, about the fact that the respondent was the defendant to the claims. The respondent, the appellant's contracting counterparty, was the only person who could be a respondent to the claims. Lord, secondly, the respondent submits in paragraph 41 of its skeleton argument that we have conflated different stages of the analysis, ignoring the distinction, as they put it, between jurisdiction and utility. We do no such thing, and the point we make is really a straightforward one, which is that the judge can only have concluded that the English court had jurisdiction under Article 25 of the regulation in respect of the claims in the particulars of claim, if he was satisfied that there were disputes, to quote the language from the article which would be familiar to the court, which have arisen in connection with the particular legal relationship between the parties as constituted by the agreements between them, but also that the respondent was the correct defendant to those claims. And we submit it wrong to hold that the court has jurisdiction over a defendant in respect of claims made against it, but at the same time to hold that the defendant is not to be regarded as the correct respondent to those claims. Lord, thirdly,
when you use the word utility, or when the judge uses it, what is that taken to mean?
that is, as we say in our note, if your lordship look at it, it's on the second page, it's by reference to paragraph 178, because as far as the judge was concerned, the claim lacked no useful purpose, because it wasn't the defendant who was primarily interested in the determination of the issues, and there was another party, the OPJ, and that's what he says further on in 178. The submission that had been made by the respondent to the judge below was in the context of why a court might not grant declarations at the end of the day. And of course, one of the arguments that is often employed is that there's no utility in the declarations, for example, because the issue's academic or because it's stale. And the judge seized on that language in order to then go on and make his conclusions as he did in 178. But your lordships, no, we challenge that. It's not quite clear what the judge meant beyond what he said in 178.
Well, is utility simply a dressed-up way of saying there's no point in these proceedings?
That's what we understand him to say.
Right, because it isn't a term of art that has some specific defined meaning. It's just an English word that we have to follow what the judge's reasoning is.
Correct.
With reference to.
Correct. My lords, similarly, it's inconsistent for the judge to have concluded, as he did correctly at paragraph 181 of the judgment, that the claims met the summary judgment standard and thus that there was a serious issue to be tried, unless he was satisfied that the respondent was the correct defendant to those claims. And my lord, then, picking up your lordship's point on utility, and as I say, we've identified this in the document, the judge was of the view that there was no point in the claims, no purpose in the claims, because he thought the real adversary was the OPJ, and there was no prospect, obviously, of the OPJ coming before the court.
The OPJ is an adversary in the sense that there is a dispute between you and the OPJ about whether there is criminal liability. But it may be said, I suppose, that that doesn't preclude the existence of a dispute between you and the Secretariat about whether there should be civil claims or compensation arising out of the transaction.
Two answers to that. First of all, my lord, the only dispute between the OPJ and any appellant is the fourth appellant. There is no dispute, even in the criminal sphere, between the OPJ and the corporate appellants, 1 to 3, who have never been the subject of any investigation and, of course, are not the party to the prosecutions. As to your lordship's second point, your lordship is right. The fact that Mr. Mincione may be, as it were, the defendant to the prosecution brought by the OPJ in the Vatican does not affect the issue of whether there's a dispute between him and the other corporate appellants against the Secretariat of State, which the judge must have realised there was and appreciated there were, because otherwise he couldn't have held that the English court had jurisdiction under Article 25, and he couldn't have held that the claims met the summary judgment test, and he couldn't have held that there were serious issues to be tried. My Lord, so the issue of utility is, as we've said, bound up with the very issue of who is the correct defendant.
And also this is taking place in a context where the OPJ and the Secretariat are two, albeit apparently independent, arms of the Holy See. That the court has to look at the reality of that situation in deciding what the stance of the individual's participants is.
Well, my Lord, can I just respond as follows? The reality of the situation as far as the English court is concerned is that there are contractual claims brought as between counterparties to contracts in respect of jurisdiction clauses, which are properly regarded as exclusive English jurisdiction clauses. And that is the reality. And at the moment, I'm just...
Yes, I'm sure you're anxious that I don't swim out too deep, but I mean, the reality of this is that whether or not there's independence, as the judge was prepared to accept between the various arms of the Holy See, the fact is that they are to a degree associated parties. It isn't a situation in which there's the proceedings that are going on in Italy involve completely different parties. That the OPJ is by the structural organisation of the sea is associated with the Secretariat.
Well, my Lord, I think with respect one's got to be careful what one means by associated, because the submission of the respondent below was very clear that there was no relevant connection between the OPJ and the Secretariat of State. They pressed the point very strongly that they were independent parties. Your Lordship will have picked up the point that the OPJ took no part whatsoever in the proceedings below, didn't even produce a witness statement, and nothing was actually ever said on its behalf. So I hear what your Lordship says, but to all intents and purposes, they are separate entities. The reality may well be, as your Lordship has put it, but that was how the matter was put below. But in any event, whatever the relationship between the OPJ and the Secretariat, in the sense that the Pope stands, as it were, at the head of all, although the judge did reject a submission of mine below, that when the Pope was speaking to the media, or at least quoting to the media, that wasn't to be regarded as speaking also for the Secretariat. He was speaking personally, to the extent that the Pope can speak personally. But anyway, the real point at the moment is this, that the judge gave one reason for the stay, and that was he thought, as your Lordship has said, the claims didn't lack a purpose because the Secretariat wasn't the right defendant and the OPJ was, and we couldn't bring the OPJ before the court. And that's the sole ground of his reasons. And if he's wrong on that, the stay's got to fall. Lord, the point is this. The result of the judge's analysis is that the appellant's claim is condemned to remain in a legal limbo, because on the one hand, following on from the point I've just made, on the one hand, the appellants plainly could not sue the OPJ, no cause of action against it, not the contracting counterparty, but nor, on the other hand, could the appellants proceed with their bona fide, justiciable, summary judgment passing, serious issue to be tried claims against the real adversary of the appellants. But sorry, because it wasn't the real adversary of the appellants, according to the judge, that's to say the Secretariat.
So on the judge's analysis, the stay would cease to be necessary, would it, as soon as the Secretariat says, OK, we're not neutral anymore, we are making a claim against you in the Italian proceedings?
Well, as your Lordships know, I'll answer your Lordship's question. As your Lordships know, we make various points as to what might bring the stay to an end in Ground 6. But what your Lordship has said is right, in the sense that if the Secretariat took an action which showed that it was no longer neutral and was acting, as the judge put it, in a partisan way, such as making a claim, which is what we say they have done.
I appreciate you say it has done that already, but
well, it did happen.
On the judge's analysis, that would be a material change of circumstances.
It would.
Such as to enable the stay to be lifted.
On the judge's own analysis, yes. And to give your lordship another example, his lordship also posited as another matter which might bring the stay to an end, if, for example, the Secretariat led evidence in its civil claim. And of course, I mean, it could lead evidence at any time. It could lead evidence now. Why do these proceedings have to wait upon the whim of the Secretariat, again on the judge's analysis, to lead evidence? So, Lord, so that's what we...
Sorry, forgive me. You made a point that the companies are not parties to the proceedings, in the criminal proceedings in Italy.
Yeah.
Doesn't it follow from that the defendant to this claim is a neutral party as far as those companies are concerned?
No, my lord, because you're, with respect to finding neutrality by reference to what's going on in the Vatican, they're not neutral parties here because they have disputed, we say, the claims which we've made, well, there is a dispute between them arising out of the transaction of which the contracts were the legal instruments.
What, you mean because you brought a claim against them and they haven't given in?
Well, no, not at all. We say that there's evidence to show by reason of various media reports, and we rely on the judge's own findings in relation to which there's no respondent's notice saying he was wrong in relation to those findings, to say, well, there was obviously a dispute. This is the inconsistency argument. Lord, let me now turn to the evidence, because the judge's conclusion is inconsistent with the evidence. And there are 4 points. First of all, neutrality was hardly consistent with the respondent's prosecution of its application, by which it sought to persuade the judge below that the claims would interfere with a criminal investigation, would serve no useful purpose, that the relief sought amounted to interference with the legitimate acts of a foreign state, would be contrary to comity, that the matters forming the basis of the particulars of claim didn't constitute a justiciable civil dispute before the court, and that the relief sought and the appellant's subsequent conduct amounted to an abuse of this court's process. And, as the cherry on top of that particular cake, they also said we'd been guilty of material non-disclosure. All of those claims were rejected by the judge. So the way the respondent reacted shows that it was hardly neutral. Lord, secondly, neutrality was also inconsistent with the fact that the respondent had made, and makes now, a civil claim in the Vatican criminal proceedings. And as a preliminary point, my lords, you'll see that the judge, in his draft judgment, originally had said that he hadn't received any evidence of Vatican State law. And we respectfully pointed out to him, following his circulation of the draft judgment, that in fact there was quite a bit of evidence. And his lordship, to be fair, recognised that, and then made various substantial amendments to the judgment, but then said he hadn't received any expert evidence, even though no one had ever suggested the court did need to receive expert evidence, and the judge himself had never said the court ought to receive expert evidence. And the fact is there was no need to receive expert evidence, because the relevant provisions are absolutely clear, and I'll take you to those in a second. Lord, the judge's conclusion at paragraph 70, that by seeking to register as a parte civile, or even if it has done so, the defendant hasn't taken a position that the charges are true, but merely asserted a right to compensation in the event they're proved, it is wrong, and it's contrary to what the respondent itself stated in its own documents, which I'm going to show you presently, as presented to the Vatican Criminal Court when advancing its civil claim. But before those, I just want to show, Lords, briefly some of the relevant provisions. If your Lordships take up the supplemental bundle and go to tab 18, page 280, your Lordships have that. So that's an extract of the Civil Code 2043, just setting out the obvious proposition that someone who causes another person loss has to compensate that person if it's through a malicious or culpable act. And over the page, part of the Criminal Code, the relevant provision, Article 7, the offence may result in a civil action for damages and restitution. So it's Article 7 which allows a victim of an alleged crime to bring a civil claim within the criminal proceedings. And your lordship see the third paragraph, the action is brought by the victim of the damage and may be taken against the offender. Then there are various other provisions, 8 and 9, about moratorium, effectively, in relation to civil actions pursued out with the criminal proceedings. And then, my lords, Article 13, in a civil case for damages brought or continued after conviction has become irrevocable, conviction has the status of res judicata, whether or not the act subsists, and subsequent compensation. The point is that the victim, as it were, doesn't have to make a civil claim within the criminal proceedings. They can always wait and then bring a civil claim afterwards, relying on the findings of the criminal court. My lords, then, over the page, please, to Article 53, at the bottom of page 283.
Presumably, Article 9, saying that they can't make a civil claim, means a civil claim in the Vatican. There'd be nothing to stop them, would there, from bringing a civil claim here,
of course,
if they wanted to?
Yes, absolutely. Correct. Correct. My lord, Article 53, then, at page 283, a civil action under Article 7 is brought in the criminal proceedings when the plaintiff joins the proceedings. So that makes it clear that when the victim, when the parte civile, civil party, joins the criminal proceedings, that's when the Article 7 claim, the civil claim, is made. And then Article 54, whoever intends to join a civil action submits a statement with the registry and so on. And then lastly, Article 63, page 286, top of the page, the plaintiff may provide evidence to ascertain the facts that establish the damage. And Lord, let me show you some documents which were in evidence before the judge. Lord, first of all, in the supplemental bundle, please, at tab 14, at page 243, in order. This is the document entitled Special Mandate for the Civil Action and so on. And your lordships will see from that that the respondent and APSA, which was an assignee of various claims which the Secretariat had, through its official representatives, including with regard to the Secretariat Cardinal Parolin, the Secretary of State himself, grants a special mandate to Professor Severino so that in their names, as injured and damaged parties in the aforesaid proceedings, not, I might add, as theoretical, contingent, or putative damaged parties, she can arrange the representation and civil action incidental to the criminal proceedings against, amongst others, the fourth appellant, in relation to all the offences and all violations charged to them and described in detail in the charges in the indictment. And then 244, for the restitutions and indemnity of all damages to assets and otherwise incurred by the respondent and APSA due to the facts described in the aforesaid requests. And your lordships see that Professor Severino is thereby appointed, and she's granted every broadest faculty connected with the exercise of the mandate. And she's also appointed for the declaration of civil action incidental to criminal proceedings and for the reading and development of the pleadings. And then, my lords, we come to this passage, the penultimate passage. The undersigned, in the aforesaid capacities, furthermore, represent the wish of the respondent and APSA that all offences and violations charged against the accused in the criminal proceedings indicated in the title of this document be pursued. I'll come back to that point in a bit. My lords, then please, if you can go back in the bundle to page 240. Your lordships see the declaration of civil action itself presented by Professor Severino, and under the heading whereas, in the middle of the page, that declaration of civil action follows from the request and so on. And then, my lords, over the page at 241, the second recital records that the respondent and APSA...
Sorry, what is this document achieving?
This is the, if you like, the originating process.
It's the joining document.
It is the joining document. It's the document by which they make the civil claim within the criminal proceedings. Your lordship is absolutely right. And then, my lords, the second recital recalls the respondent and APSA on the basis of the request for the issue of the above-mentioned writ of summons, a related writ of summons that mentions the same, are injured parties by the offences and violations mentioned in the charges, to which reference is made in full, for having incurred significant damage to assets and otherwise, including therein damage to their own image, that they incurred due to the conduct of the above-mentioned individuals. And it's then stated that given the above, Professor Severino, as attorney to the respondent in APSA, as injured and damaged party, declares that she takes civil action incidental to the criminal proceedings for the purpose of obtaining full indemnity of all damage to assets and otherwise as a consequence of the offences and violations charged. And then, my Lord, 242, there's a request the declaration served on the OPJ and the accused parties. And then, my Lord, thirdly and finally, at page 238, the first document in that tab, that is simply the report that the civil action has been commenced, as it were. That's a Vatican Court registry document, and the second paragraph simply records that Professor Severino has lodged, as it were, the civil action and so on. I don't need to trouble you anymore. And again, for your Lordship's references, Mr. Walsh, the solicitor to the respondent, in his fourth witness statement, supplemental bundle, tab 17, page 254, confirms that action was brought pursuant to Article 54 and Article 7. So, my Lords, we submit that from these documents, the 7 following matters are clear. First, the respondent has taken civil action. Second, the respondent has taken civil action when it did. It might have waited. It might have waited for a further time in the criminal process. It might have waited till the conclusion, but it didn't. Third, the respondent considers that it is an injured and damaged party, because that's what Article 7 speaks of, and that's what the documents actually state. Not, my Lord, that it might be an injured or damaged party if the criminal charges are proven. Fourthly, my Lords, that the respondent considers that it has suffered significant damage and considers also that the damage was caused by the fourth appellant and others. Fifthly, the respondent's purpose in taking civil action is to obtain a full indemnity to all damage to its assets and otherwise incurred by it due to the said conduct. Sixthly, my Lords, that the respondent has appointed lawyers with the broadest possible special mandate, or a special mandate by which they granted every broadest faculty in relation to the civil action. And lastly, my Lords, that the respondent's wish is that all offences and violations against the accused in the criminal proceedings indicated in this title document be pursued. I mean, particularly that last point does really take the shine off the proposition. In fact, all these points in our respectful submission, that the respondent is a neutral party.
You say there's nothing precautionary about this?
Nothing precautionary.
Had they wanted to sue to the maximum extent, there's nothing more that they needed to do?
Correct. My Lords, we submit that the respondent's own documents show that the judge was wrong when he stated in paragraph 70 of his judgment, and I quote, "Based on the words of the document I set out above, my understanding is that by seeking to register as a parte civile, or even if it has in fact done so, the defendant hasn't taken a position that the charges are true." That's wrong. Secondly, my Lords, with respect, the judge was also wrong when he stated in paragraph 72, "There is no suggestion in the materials to which my attention has been drawn that it's required to take a partisan position on whether the crime in fact took place." I might add, whether it's required to or not, the fact is it did. And my Lords, thirdly, the judge was, with respect, wrong when in paragraph 73 he described the claim as a contingent claim which had not been advanced. It plainly had been advanced, as the declaration of civil action and the report of civil action shows. And these are not, my Lords, with respect to the respondent, as it submits in paragraph 47C of its skeleton argument, mere criticisms of weight that the judge attached to the evidence. This is where he was, with respect, plainly wrong. And, my Lord, it was also wrong for the judge to have expressed himself in the way he did in paragraph 73, when he said there was no evidence that the respondent had submitted evidence to demonstrate both the facts and damages it had suffered, and these words, or that it would necessarily do so. My Lords, in circumstances where the respondent had started an Article 7 civil claim, had engaged legal representatives on its behalf, and had expressed itself in the way in which it had in its civil claim document. It is fanciful to suppose that the respondent would not pursue its own claim and would not lead evidence to support its claim. And really, with respect to the judge, what he should have said was that there was no evidence before him to suggest that it wouldn't lead evidence to support its own claim. In any event, the issue of leading evidence was in the future, and it was sufficient for the judge simply to focus on what had happened.
Have I correctly understood that because the Vatican proceedings got off to a false start, they had to do it all over again when the proceedings resumed, but presumably the current civil claim is materially identical to what you've just shown us.
So,
is that right? I mean, you don't need to take us to
no, I'm not going to.
if it's the same. But
the answer to your lordship is yes. The only point I'd make was, just in case it said on the other side, the indictment as against the fourth appellant was returned. We say it was quashed. They said, oh, it wasn't quashed because the indictment survived, but we accept it was returned. But the broad point is, yes, your lordship's right. They had to start again in relation to Mr. Mincione. And yes, there are new civil claim documents. I'm not going to take you to them. They're in the fresh evidence bundle at tab 4, which are in the same terms.
Well, that's what I'd assume, but I just wanted to understand.
Precisely so. My lords, thirdly, this is a small point, but there was an exchange between Mr. McParland, late Mr. McParland, greatly missed, and the judge on transcript bundle tab 1, internal page 22, and it's referred to in footnote 21 of our skeleton argument for this appeal, when the judge asked the learned friend, so your client has stated a position that it looks from what's become public that they've been the victim of a fraud, to which the response was yes. It's true there were further exchanges, a small point, but we say that's not consistent with neutrality. And my lords, fourthly, there are the media reports, and I think I can take this swiftly. The fundamental point about the media reports is, and the judge addresses this in paragraphs 62 and 63 of the judgment, was that it was accepted for the purpose of the hearing, because the Secretariat had been silent as to the point that they were the source of the media reports. And the fact that the respondent was the source of the reports showed that the respondent was content that the media be fed a slew of materials which cast doubt on the bona fides of the transaction and suggested serious wrongdoing. It didn't have to be the case that the reports clearly stated that the respondent was in terms disputing the transaction. It was sufficient that they had been the source of these reports. And again, those are not the actions of a neutral person. And can I just show your lordship, I think, they're at tab 2 of your lordship's supplemental bundle. I'll let your lordships, only a few pages, but I can just rattle through them quickly if I can. Page 19, there's something from the Eurasia Review. In the 6th paragraph, pre-penultimate on that page, in October, Pope Francis authorised raids at the office of the Secretariat of State. And then the 4th line, the Pope later called the matter a scandal, but apparently, according to the judge, he was speaking in a personal capacity. And then, my lords, at page 20, there's reference to Mr. Mincione, and I'll let your lordships read that in due course. Don't want to take up time now. 21, there's a Financial Times article, and again in October, 5th paragraph down, October last year, Vatican police raided the office of the Secretariat of State, took away documents linked to the deal, suspended private officials. There is corruption. We can see it. Pope Francis said a month later, again apparently speaking in a personal capacity. And then, my lords, the Corriere della Sera article, 3rd of May 2020, and Vatican turning point regarding the building in London, Pope removes suspect, seeks a new mortgage. Then, under the heading Secret Accounts, at the bottom of the page, reference to various matters. And then the 4th line from the bottom, Pope Francis himself, on his return from Japan, had clearly stated, there is corruption, you can see it, while the Secretary of State that's Cardinal Parolin, had defined the whole affair as opaque, even if it's not certain that crimes can be proved, so much so that for this reason, that a civil action for damages is not off the table. And the judge dealt with this, my lord, paragraph 66, Roman 3 of the judgment, with respect, slightly odd paragraph. He said, I reject the claimant's submission that the translated Il Corriere article should be read as reporting a threat by the defendant itself to bring a civil claim against the claimants. That is a possible reading. So he accepts it is a possible reading. He says, but not the only one. But his lordship then doesn't actually go on to say what the other possible readings might be. And then he says that, oh, well, it's all hearsay. He doesn't want to give it lots of weight, which kind of misses the point, not only in relation to the fact that the respondent was the source, or seemed to be the source, but also this. What was foreshadowed in the Corriere della Sera article, a civil action is not off the table, came to pass. And the civil actions that's being referred to here could only be a civil action by the Secretariat as the Vatican counterparty. And the only defendants, at least in the context, or at least relevant defendants, would be my clients as transaction parties. But the fact is, it came to pass. And had the judge kept that in mind, he couldn't properly have described the respondent as a neutral person, as it were, standing apart from the fray, and then gone on to say no significant weight should be attached to that article. So, my lords, for these reasons, we submit that the judge's sole reason and sole factual basis for a stay, based on the respondent's neutrality, and that the OPJ was the appropriate respondent to these contractual claims, was flawed. And it follows that his exercise of discretion, therefore, was flawed and should be set aside. And I should just make very briefly this point, it's a point we make in paragraph 41 of our skeleton. Even if the respondent was, as the judge put it, a neutral, why should that be a ground for a stay? Let it be assumed it's a neutral. In circumstances where his lordship had said these were justiciable claims, which were properly the subject of Article 25, passed the summary judgment test, serious issue to be tried, why should they be held up? And it's a point which, if I may respectfully pray in aid, was made when, by Lord Justice Males, and I know his lordship was only making a point in the context of admission, that's well understood, but it's a point nonetheless which we submit has real resonance, and that is that effectively all the issues concerning this action or the transaction are concerned with England. And the critical issue, the essential issue of valuation, is something which not only should be decided here because that's what the contract stipulates, but self-evidently should take place here. English property, Sloane Avenue, Chelsea, London, English valuations, it's something which should be tried here. So, my lord, that's what we want to say on ground 4. Let me now turn to the terms of the stay itself. This picks up ground 6 and also a point we make in ground 5A, Roman 5. My lord, the stay should not have been ordered by the judge in these terms. And there are 3 broad submissions which we make and which I'll develop.
Well, can I just rewind for a moment?
Yes.
Let's suppose you are right and that all of this stands or falls on our decision in relation to ground 4. And in a sense, other matters are either unnecessary or consequential. Your ambition is to reinstate your declaration claim in full.
Correct.
If we'd found that the judge was wrong, we'd be exercising a fresh discretion.
You wouldn't, and we probably misspoke in our skeleton.
Could we work through this, please?
I'm so sorry, Lord.
No, I want your help.
Oh, I'm
I want
sorry,
your help on it, yes.
Well, Lord, yes. We weren't the applicants, of course, for the stay. And therefore, if we persuade your lordships that the stay should be set aside on the usual basis that the court sets discretionary orders aside, then that is an end of the appeal. There is no fresh application which is made by the respondent for a stay in the event that it's set aside.
Right, because there's no respondent notice.
There's no respondent. The respondent's notice says that the judge's decision should be upheld for different grounds. And what they rely on are what has happened subsequently in the Vatican as underlining why the judge was right initially. So there is no fresh discretion to exercise. Lords,
one possible concern is that the declarations which you seek seem extraordinarily wide. I mean, it may be, if the stay were to be lifted, that there would be something in there which would, depending on how the facts came out, be a sensible declaration for the English court to grant. But what you're asking for at the moment, which is really that I haven't counted them, but there's any number of declarations you're seeking in your paragraph 34, and it seems rather implausible, at any rate to me, to think that the English court would grant all of those declarations. How is that to be dealt with by us or by somebody else, and at what stage?
Well, I answer your Lordship's question. First of all, in relation to the declarations themselves, they track the representations and statements made in the contracts or are consequential on them. They are exactly the sort of declarations which we see in the ISDA cases, where particularly the banks pick out of the ISDA financial documents all the various representations and warranties, plead those as declarations to be made by the English court for declarations of non-civil liability and consequential directions. So that's the scheme of it. That's what.
Well, I know that's how people plead them, but that doesn't necessarily mean that's how the court grants them.
Absolutely right. But that's not a question. That's not a matter for my lords. That's a matter for trial at the end of the day. That's a matter for argument. And your lordships know that in a lot of these ISDA cases, for example, even particularly ISDA is a good example, if and when they get to trial, because many of course don't, but if and when they get to trial, there's an argument about what declarations, if any, the court should be making. And sometimes the court grants declarations 1, 2, and 3, and it doesn't grant 4, 5, and 6. So that's not a matter for your lordships. What your lordships are concerned with is whether the judge was right to stay this whole action, an action which was commenced almost 2 years ago and has been lying dormant. My lords, let me turn to the 3 broad submissions we make in relation to the terms of the stay. First of all, the stay wasn't what the respondent sought and wasn't the subject of any discussion at the hearing. Secondly, there's a lack of clarity in the terms of the stay. In particular, it's uncertain what events might bring the stay to an end. And thirdly, it offends, or is likely to offend, the appellant's effective right of access to a court within a reasonable period of time. Let me take the first submission now. The stay, which your lordships have seen that the respondent sought in its application notice primarily, was a stay under Part 11, 6. That, of course, fell by the way when the whole Part 11 application was rejected. And in the reasons section of the application notice, the respondent, probably in the wrong place, didn't matter, but they sought a case management stay. So the case management stay which they sought was initially a stay pending the conclusion of the investigations into Mr. Minchone. That then changed during the hearing to a stay until the determination of the criminal proceedings. That was the case which we had come to court to meet. That was the case which was advanced by the respondent before the judge. And that was how the judge understood the case to be advanced. And indeed, let me just show your lordships one point, because your lordships will have seen in the judgment, the judge referred to the fact that at the start of the hearing, he set out a number of issues which he wanted the parties to address. And can I just show your lordships what he said about what he described then as issue 4? That's in the transcript bundle. Please, it's tab 1, page 6, line 23. What he said there was 4th issue: to the extent that the court can and should exercise jurisdiction under Article 25, should I exercise my jurisdiction to stay the claims that fall under Article 25, pending the conclusion of the ongoing criminal proceedings before the Vatican City State Court. So that was how it was all understood. And the issue was not, my lords, expressed as, oh, well, should the court grant some other stay? And if so, what and for how long? So when my lords, in the last section of his judgment, his lordship rejected the respondent's application for a stay until the determination of the criminal proceedings, as he put it, being too determinate. He should then, in fairness, have gone on to dismiss the application for a stay in toto. And he was wrong to make an order, as he did, in terms which, as I say, were not sought by the respondent in his application notice, which hadn't been argued for by them in evidence, written submissions or orally, hadn't been the subject of argument by us, because we didn't know about the point, obviously, and when the judge had not given any indication that he was considering granting a stay on some basis other than that contended for by the respondent. And I should add this, your lordships will have seen in the bundle, that when, before the judge circulated his draft judgment, he sent an email to the parties, inviting them to make submissions as to whether he should go on and make submissions, findings regarding summary judgment and the issue of a tribal issue. And the parties responded, and in due course he expressed himself in the way in which he did. He might have, in those emails, have said, oh, by the way, I'm also thinking about granting a stay on some basis other than that contended for by the respondent, but he didn't. So we say that wasn't an appropriate way to proceed with respect. It's difficult to see how that furthers the overriding objective. Lord, as to the second submission...
Sorry, Mr. Summit, just on this first point.
Yeah.
As I understand it, your complaint is that limiting the stay to a material change of circumstances is too vague.
This is the second point that I'm going to come to.
Okay,
First
I'll
point,
keep quiet then.
I'll
I'll keep quiet then.
yes.
But I thought that was your first point.
No. The first point is we had no idea he was considering this. It wasn't the subject of argument.
I see.
The only stay that was sought by the respondent was until the conclusion of the criminal proceedings. So I'm now turning to the point which your lordship expressed.
But, I mean, you don't have a separate ground of appeal that there's a failure of due process.
Well, we don't, in terms, your lordship is right, say there's been a failure of due process, but we do refer to it in our ground 6. And we do...
brackets.
Well, brackets were never a bad thing. Look, we recognise, it's a valid point, but this court, in general, wants to get to grips with the substance and the real meat of things, and if I may respectfully put it like that. So I do make the point, because it's an important point, but it's not the only point, if I can put it like that. My lords, material change in circumstances. The trigger of a material change in circumstances, let alone with the further qualifications that materiality was to be judged by the reasons in the judgment, are words not usually found in an order for a temporary stay in the context of parallel foreign proceedings. The phrase is more associated, of course, with setting aside an order of the court under CPR 3.17. And indeed, my learned friends refer to the decision of this court in Tibbles. But in the sort of Tibbles case, in the CPR 3.1 case, what the court is doing is looking at specific events which have occurred, so that there's no doubt about the identity of the events, and then seeing whether they give rise to the relevant material change in circumstances. That's quite different from what's gone on here. Here we don't know, actually, what the specific events that might take place in the future that might constitute a material change as the judge expressed himself, because they obviously haven't yet occurred. And that of itself, in our submission, gives rise to uncertainty, quite apart from the issue as to how you judge materiality. But let me now turn to the qualification phrase of the judge, materiality be judged by reference to the reasons in the judgment. First of all, I'm not going to spend any time on this one, what does by reference to mean? I mean, lawyers would have a field day in relation to interpretation of those three words. But in any event, as we submit in relation to ground 4, the problem in referring to his own reasons is that these reasons, for the reason because of the submissions I've been making to my lords earlier, are themselves inconsistent and, we say with respect, illogical. So on the one hand, you have the judge concluding, as I've said, that the respondent is the right respondent, right defendant to the claims for the purpose of Article 25 and summary judgment. And apparently it's not the right respondent for the purpose of a stay. And then, similarly, there is a confusion over the arguability of the claims. On the one hand, he says, as I've already said, they passed the Article 25 test, they passed summary judgment test, but nonetheless, they shouldn't be tried. The second point is this. If the reasons which the judge refers to are the future events which he refers to in paragraph 179 of the judgment, then that results in, at best, confusion and incoherence, and at worst, with respect, a likelihood or a real risk that the stay will not be lifted until the very event which the judge himself had rejected, namely the conclusion of the Vatican criminal proceedings. And I'll explain why. And there are 4 points I want to make by way of explanation. First of all, one example the judge gave in paragraph 179 was that the prosecution of Mr. Mincione might be dropped, or it might fail, or succeed. But the prosecution against Mr. Mincione would only suffer those fates upon the determination of the criminal proceedings vis-à-vis him. And that was, as I say, the very point in time he'd rejected. The second example he gave in paragraph 179 was that the respondent itself might take a partisan position, either in the course of its party civile action or in some other way. But it's difficult to see how, on the judge's view, the respondent would take a partisan position at any time before the conclusion of the criminal proceedings, because he had expressed himself in paragraph 195 of the judgment that the respondent was hamstrung by its proper role as a neutral party awaiting the outcome of the criminal proceedings. So the judge must have meant investigation. The judge must have meant, when he used the word investigation, to refer to proceedings. And indeed, the respondent's submission, referred to in paragraph 57 of the judgment, was that it was neutral until the outcome of those proceedings. So again, a point in time which the judge had already rejected. The third point is it isn't at all clear what would constitute the respondent taking a partisan position in circumstances where the judge had already concluded it wasn't taking a partisan position by instituting a civil action, engaging lawyers with the broadest possible of mandates, serving the action, expressing itself as it did in the party civile documents, and by being the source of media reports. All matters which were not partisan, and therefore it's hard to understand what it would have to do to become partisan, save the point about leading evidence. My lords, fourthly, the last point is, and it reinforces the submissions respectfully which we've made under ground 4, the judge had held, of course, that there was no utility in the action in paragraph 178, because the real adversary was the OPJ, and there was no prospect of the OPJ ever becoming a defendant to the action in this court. So that would suggest that the stay would never be lifted, because circumstances, my lords, will never arise when the OPJ is the proper defendant, when the OPJ could properly be brought before this court. And so that gives rise to the problem that, as we'll see when I shortly come to grounds 1, 2, and 3, that the authorities make clear in the context of where this court has jurisdiction under the regulation, that any stay should be temporary. But the difficulty is that there is, at worst, a likelihood, at best, a substantial risk that any stay on the terms the judge ordered would be permanent, in the sense that it would last until the conclusion of the Vatican criminal proceedings. Again, a time rejected by the judge. And there's, and indeed, can I show your lordships, please, in the transcript bundle day 1, page 30 of the bundle, internal page 110, at line 23, my learned friend said below, and that's why a stay would be, it's not just but see the outcome. In the context of this case, it would actually determine whether or not these proceedings ever took place at all. That was a recognition by the respondent of the very point that I have just submitted to your lordships. And there's a further practical point, of course, that, even leaving aside all those points, that a judge hearing a lift the stay application would, instead of being presented with a clear order which was workable and which he or she could work out whether the stay should be lifted, is instead presented with a farrago of matters to consider and real confusion as to what the terms of the stay are. Lords, then coming on to the third and last point in relation to ground.
Sorry, just when you're on the terms of the stay, I am troubled by this because, as far as I can see, if the stay as a stay, just as an order, had said the proceedings are stayed under the inherent jurisdiction of the court and the parties have a liberty to apply, that's an order which ought to make regularly, and as far as I can see, isn't one that you could strike down for being ambiguous. And if you asked, as an incautious judge, if you'd asked me what it meant that if there was a material change of circumstances, judged by reference to what was in the judgment, among other things, that would be what the court would do on an application to lift the stay. So I'm troubled by the submission that you're saying that the order, as a matter of drafting, is ambiguous. I understand why you criticise how an order of this kind works in this case, but that's a different question.
Right. The submission I'm making is the latter. I'm confining my submissions to the particular facts of this case. I'm not seeking to advance any submission as to what any other judge might do in any other case. It's just this particular case.
Your real complaint, as I think I understand it, is not so much with the, with the terms of the order, but with the content of the judgment which is referred to in the order. And you say because the judge was wrong about this, that, and the other, and inconsistent about such and such, it's a difficult task for anybody wondering whether to lift the stay. But it seems there's nothing wrong with the order. You're either right or wrong in your criticisms of the judgment.
Yes, it's the content of the judgment. Your Lordship is right. The only additional point which I'm making, which is that on the one hand, a judge rejected a point in time to lift the stay, which was the determination of the Vatican criminal proceedings. On the other hand, he posited as examples, which might constitute apparently a material change, events which themselves would not occur until the determination of those criminal proceedings. But effectively, that's another way of me making the same point my Lord has just made. Lord, let me just turn then to the last of the submissions in relation to the stay, and that is the denial of an effective right of access to the court within a reasonable time. I'm not going to waste time and take your Lordships to Abraham and Thompson. Your Lordships will be familiar with that case and the dicta of Lord Justice Potter. And I'll just give your Lordships the reference, Authorities Bundle, tab 2, page 52. It's broadly that if you've got a good justiciable, non-abusive case, then all other things being equal, you should have the right to access to court. That, of course, was a formulation before the Human Rights Act 1998, and following which the rights afforded to persons under the convention could be enforced directly in our courts. In Reichhold, which of course was the case which sets the expression rare and compelling circumstances in the context of parallel proceedings, the Court of Appeal stated, and again I won't take your Lordship to it because of time, but it Authorities Bundle, tab 5, page 93, at 186B to C internal, Lord Bingham said it's plain that in exercising this jurisdiction, which is to stay proceedings under the Reichhold principle, the court would have to be mindful of the effect of Article 6. And as to Article 6 itself, we address the submissions we make in paragraphs 54 to 56 of our skeleton argument. There are two rights which we say have been infringed by the order: the right of effective access to the court and the right to have claims determined within a reasonable time. As far as the right of effective access to the court is concerned, we rely on the decision in Marini and Albania. Again, if your Lordships are content, I'm just going to give your Lordship references because I want to get on the other grounds. And that's Authorities Bundle, tab 28. That was a decision which was signed by the UK judge, Sir Nicholas Bratzer, maybe of some relevance. And the facts, in broad terms, were that the applicant was bringing various claims against the government of Albania, and he was achieving success, but he got to the Constitutional Court, and the Constitutional Court dismissed his appeal on the basis they couldn't reach a majority vote. That was all. He didn't make any other application to the court, but he complained to the European Court of Human Rights, and at paragraphs 112 to 113 of the decision, which is at page 839 to 840 of the Authorities Bundle, tab 28, the court set out the principle that Article 6.1 secures to everyone the right to have any claim relating to civil rights and obligations brought before a court or tribunal. That's the right to a court, to which the right of access constitutes one aspect. And then the right to a court isn't absolute, it's subject to limitations. But then in the middle of that paragraph it says this: however, these limitations must not restrict or reduce a person's access in such a way or to such an extent that the very essence of the right is impaired. My lords, and the reasoning of the court is at 121 to 122, that's at page 841 of the Authorities Bundle, and it was that the government of Albania relied on the fact that dismissal of the applicant's complaint didn't entail permanent consequences for him because he could renew his appeal if there was a change in circumstances, which has an echo of the point made by the respondent, oh, well, we can always apply to lift the stay. The court is, however, unable to accept that the mere possibility that circumstances might change and the applicant might receive a final determination of his appeal at some undefined future point in time could satisfy the requirements of legal certainty. 122, Constitutional Court's failure to reach a majority on the proposals before it left the applicant without any final determination and so on. So that's what we say about the right of effective access. As far as determined within a reasonable time is concerned, the point there was that Mr. Marini had brought several claims, and some of the proceedings had lasted...
This is all fairly basic, isn't it?
Yes.
You do need to dress up a submission about reasonable time so richly.
What we say is I'll cut to the chase. What we say on effective access is, your lordships have heard my submissions in relation to the stay, and we say because of the criticisms we make, therefore we don't have effective access.
Well, it's an indefinite stay at a time in which you wish to be forging ahead with your campaign.
That's the point in one. The second point is within a reasonable time. These proceedings have been on foot for over 2 years. The respondent hasn't even pleaded a defence, and this is despite the fact that the judge recognised that the claims should be tried in England when they're tried. And of course, even if Mr. Mincione is found guilty in the Vatican, that doesn't dispose of the claims at all, and indeed, even if he's acquitted, the claims are going to continue. So it's not going to determine any claims by the first to third appellants, nor would the Vatican ruling, if there was one adverse to Mr. Mincione, raise any issue estoppel certainly as against the first to third appellants, and notably the judge didn't suggest that it would. And the judge found, of course, that our proceedings here didn't interfere in any way with the Vatican proceedings, and so therefore there is no legitimate aim in staying the proceedings. That's the picking up the principle which I referred your lordships to from Marini. And this is subject to the point which my Lord Justice Males made about the quantity or breadth of the declarations. This is a relatively straightforward claim for declaratory relief based on the express terms of contracts between the parties, and as I said before, the essential issue being one as to the valuation of this London property, and that's something which should be determined here, we can get on with here. So that's what I want to say, my lords, in relation to grounds 6 and 5A5. Can I now turn, please, to ground 1, and there are, which I think I can take fairly swiftly, which there are 8 steps in the argument. The first, the English court has a wide case management power to grant a temporary stay of proceedings, otherwise properly proceeding here. Where to do so would serve the overriding objective. And that's by virtue of section 49.3 of the 1981 Act, and of course CPR 3.12F. Secondly, but where a stay is sought by reference to proceedings in another jurisdiction, the power may be exercised only if 3 conditions are met, and they are these. First, where the proceedings are properly described as parallel proceedings, which raise similar or related issues between the same or related parties. And secondly, where the earlier resolution of those issues in the foreign proceedings would better serve the interests of justice than by allowing the English proceedings to continue without a temporary stay, and only in circumstances which are rare and compelling. And Lord, we get that from paragraph 99 of the Supreme Court's decision in the Unwired case, which I don't propose to show you, Lordships. We've referred to it, and there it is. Contrary to the submission made in paragraph 27 of the Respondent's skeleton argument, it is not our case that a temporary stay may only be granted where the Reichhold principle applies. It's clear from Unwired, which we cite in paragraph 20 of our skeleton argument, the court may grant a stay in other scenarios, for example, to allow the parties to go off and mediate their dispute. Rather, our submission is that if a stay is sought by reference to proceedings in another jurisdiction, then the principle which is engaged is the Reichhold principle. Thirdly, and again, contrary to the submission in paragraph 27 of the Respondent's skeleton, the decision in Reichhold is limited to the kind of parallel proceedings mentioned by the Supreme Court in Unwired. And it's notable the Respondent has not produced any authority to the contrary. And
You've just put forward these points as effectively rules of law, that you can only have a stay if these conditions are satisfied, or are you putting them forward as, I don't know, factors which should be taken into account and which should weigh heavily?
I'm putting them forward as principles of law which are established by the authorities and applied by the authorities. We're not aware of any other authorities which seek to apply any different principles. They're more than just factors. I mean, what I've done is quote directly from paragraph 99 of the Supreme Court's decision in Unwired. And in the as I say, in the context of parallel proceedings, then it's the Reichhold principle which applies in the context of case management states. So I do put it as a rule of law. I do put it as high as that, yes.
Okay.
My Lords, in the Reichhold decision, Reichhold case itself, which was I may turn it up briefly in view of the time, but it was a case where effectively the claimants in both the action and the arbitration were the same, and effectively making the same claim. You had the claim in the arbitration in Norway against the Norwegian seller for breaches of the contract, and then the action in London, which was in tort against Goldman Sachs, effectively Hedley Byrne type action, because it hadn't disclosed information which cast doubt on the financial profitability of the object company in tort for negligent misstatement. And there were various contractual provisions, and I'll just refer the court to them, which were referred to at first instance by Mr. Justice Moore Bickersy, then was at 182 D through to 183 F, and it wasn't a convention case, and not a conventional regulation case. And it was an unusual case because Reichhold, his lordship found, didn't have any legitimate reason for pursuing Goldman Sachs here, as opposed to pursuing the arbitration in Norway against Jotun. Quite different here, where we only have one possible defendant who we can sue, and that's the Secretariat of State in this jurisdiction under these contracts, as I've said. But what the passage I want to show, my lords, please, and it's in the authorities bundle at tab 5. It's one little passage in the judgment of Lord Bingham at 186, internal 186C, page 93 of the bundle. And his lordship, so the Court of Appeal didn't disturb Mr. Justice Warwick's order. And what his lordship, the Chief Justice, said at letter C is, I for my part recognise fully the risk to which Mr. Carr drew attention, but I've no doubt that judges will be alive to these risks. That was the risks in granting the stay. It will very soon become clear that stays are only granted in cases of this kind in rare and compelling circumstances. So the reference to cases of this kind, we say, is a reference to the cases of parallel proceedings as described by the Supreme Court in Unwired. My lords, the fourth point we make is this. It follows that if a court is proposing to grant a temporary stay on the basis of the Reichhold principle, then it's first got to ascertain whether there are any relevant parallel proceedings. If when the court is asked to grant a stay, there are no relevant parallel proceedings, then the Reichhold principle has no application. And it would then follow that there must be some other juridical basis sought for the stay. Fifthly, in this case, as the judge recorded in paragraph 193 of the judgment, the respondent accepted that the relevant principle was the Reichhold principle. That was the principle which the judge thought that he was applying. No other principle was identified. Sixthly, however, at the date of the hearing before the judge, there were no parallel proceedings involving any of the parties to the English action. Because at the time before the judge, all there was investigations into Mr. Minchone. And the judge accepted that at paragraph 135 of the judgment, when he said, the claimants point out that there are no criminal proceedings on foot because the indictment was returned to the prosecutor, and also that there's not even an investigation into the corporate claimants. I accept that these points are correct, he said, but then he said they are objections going to form rather than substance. He said the substance of the matter is a criminal investigation in which a competent criminal court is seized, and the matters alleged against Mr. Minchone and others will have obvious knock-on effects on the other claimants' interest in the transaction.
Well, was this actually a stay granted on parallel proceedings grounds at all? I mean, the judge accepted large parts of your submission that for the reasons you've given, these should not be regarded as parallel proceedings. Didn't he simply grant a stay on what he regarded as no utility grounds? The action as it currently stood, he thought, was bound to fail, which goes back to the question of neutrality. The judge's decision would probably have been the same if there had been no criminal proceedings in the Vatican, because the respondent had not taken any position on his view.
I see the logic of your lordship's points. I see the thought. That may well be ultimately what his lordship did decide. But the point was he appeared to be applying the Reichhold principle, which is the principle which is referred to as the fount and origin, if you will, in other cases. But your lordship may well be right. This is one of the problems with the judgment with respect to the judge. So that's why the point we make is there were no parallel proceedings, and that therefore the judge's exercise of discretion, that's my eighth point. The seventh point was that, which is the second point referred to in Reichhold, which is that it wouldn't serve the interests, or better serve the interests of justice, to allow the proceedings to be halted here and effectively continue in the Vatican Criminal Court. So the second condition in my step 2 of the argument wouldn't be satisfied also, and therefore one doesn't get on to considering whether there are rare and compelling circumstances. So that's why that's how we advance these submissions we do in relation to ground 1. But your lordship's going to have to decide, obviously, whether that's a right analysis or not. Equally, your lordships may come to the view that the judge was simply ordering the stay he did for the reasons given by my Lord Justice Males. And then we're back to, we're back definitely to considering whether there were exceptionally strong grounds. and rare and compelling circumstances. We can't get away from that. And it's not even suggested by the respondent that those factors or those principles should not be applied. And my learned friend, Mr. Appellant QC below, accepted that he had to show exceptional circumstances. And that's why the judge approached the matter as he did. And of course, rare and compelling, the origin of that phrase is the Reichold case. And that was the case which was referred to by the Supreme Court in the Unwired decision. So, my lords, that's what we say in relation to ground 1. Can I now turn to grounds 2 and 3? My lords, we submit that the cases make clear that where there's an application for a temporary case management stay, the court has first of all got to see if the applicant has discharged the burden of showing exceptionally strong grounds, which are rare and compelling enough, so as to mandate the stay. And it's only if such grounds are established that the court should then, secondly, go on to consider whether the grant of a stay under CPR 312F is consistent with the overriding objective. But where a claimant founds jurisdiction in England on the basis of the Brussels recast regulation, Article 25, and none of the lis pendens provisions in the regulation apply, then the grant of a stay, which has the effect of preventing the court exercising its jurisdiction under the regulation, or allowing key issues to be decided by another tribunal, constitutes an impermissible circumvention of the regulation. My lord, the principles were helpfully stated, or restated, I should say, by Mr. Justice Bryan in the Mad Atelier case. And your lordships, can I take your lordships, please, to that, which is in the authorities bundle at tab 18. And in that case, I'm going to call them Mad, with no disrespect to them. Mad brought proceedings against the defendant on the grounds that he'd broken a joint venture agreement. Jurisdiction was founded on the basis of an English exclusive jurisdiction clause. The defendant applied to strike out the claim or obtain summary judgment on the basis that the relevant disputes had been determined adversely to Mad by the Paris Commercial Court. But in the alternative, he sought a case management stay. My lords, at paragraph 82 of the judgment, at page 383 of the bundle, his lordship set out the relevant principles for case management stays pursuant to section 49.3 and CPR 3.12F, which were cited by us to the judge below. And I won't read those out, but they're pretty well trodden. The judge then rejected the summary judgment application and strikeout applications. He then turned at paragraph 163 of the judgment to whether he should grant a case management stay. At paragraph 164, he then rehearsed most of the principles he set out in paragraph 82, and he concluded the defendant hadn't demonstrated any exceptionally strong grounds for a stay. And we submit that many of his reasons have a particular resonance with this case. So 169, the judge noted the proceedings had been brought pursuant to an exclusive jurisdiction clause in favour of England, and so exceptionally strong grounds were required to justify a stay. And there were two reasons for this. Parties should be held to their contractual bargain. And in the case of an exclusive jurisdiction clause, it shows the parties did not even contemplate proceedings outside of England in respect to the agreements. And secondly, a case management stay should not be used to undermine the effect of Article 25 of the regulation in giving the English court jurisdiction. So forum non-convenience factors can't be relied on, where Article 25 designates England as having jurisdiction. To do so would amount to using the court's inherent power on case management inconsistently with the BIR. And then at 170, his lordship concluded that granting a case management stay would subvert the regulation, and in particular the lis pendens provisions in Articles 29 and 30. And that was even though Mr. Manes couldn't make an application under Articles 29 and 30. And his lordship then at 171 said the parties won't be bound in the English proceedings by the conclusions of the French civil proceedings as a matter of issue estoppel. Same point here in relation to findings in the Vatican. No risk of double recovery. 172. 173, the uncertainty of the length of any stay of the English proceedings. That was, he held, contrary to the overriding objective to deal with cases expeditiously and fairly. And it's clear that he was considering, we submit, the overriding objective here on the footing that all other factors warranted a stay being granted. And then at 174...
Presumably you can't apply for a stay in the Vatican on first C's grounds because Vatican's not a party to Brussels?
That is right, but Articles 33 and 34 allow for lis pendens provisions in relation to courts of third-party states. It's not at all clear, probably isn't the case, that, and it wouldn't apply here anyway, but the criminal proceedings don't constitute the sorts of proceedings which would be caught by Articles 33 and 34.
Well, no, but you say that the jointer as a civil party does, don't you?
You
say, as I understand it, that's a civil claim.
Yes,
that's the foundation of your argument on neutrality.
That's right, but we have the exclusive jurisdiction clause. So Article 33, 34 would be a hopeless application for them to make anyway. It wouldn't get off the ground. We're the court which has jurisdiction, first C's.
No. What I was going through my mind is that you can't do anything in the Vatican to get rid of the joinder as a civil party on Brussels regulation grounds because Vatican's not a party.
In that respect, yes.
Nodding behind.
Sorry, in that respect, that's absolutely right. Correct. That is absolutely right. Yes. Correct. Yes.
Whereas if it was France or Italy, you might be able to.
Sorry, my Lord.
Whereas if it was Italy rather than Vatican,
if it was Italy, it would be different.
You might be able to.
Yes. Correct. Your Lordship is absolutely right. Lord, and then at 174, no rare and compelling circumstances. Lord, that approach was followed by another commercial court judge, Mr. Justice Butcher, in the Banca Intesa case at tab 19. That was an ISDA case. In part, Venice had commenced proceedings in Italy, claiming, as usual, that banks had failed to comply with various advisory obligations under a mandate agreement and an investment agreement. They were subject to Italian law and exclusive jurisdiction of the Venetian courts in one case and the Italian courts in another.
Why are we going through these decisions?
We don't have to, actually, at the same time, but only to show your lordships that there is a consistent run of cases decided in these courts, in the commercial court and in the Chancery Division, which consistently apply the exceptionally strong grounds test. Which
I should hope they do.
Yeah, indeed.
So why do we need them?
I'm going to make the second one. Which consistently make the point that if a case management stay circumvents the lis pendens provisions in Articles 29, 30, or 33 and 34, then that would be an improper exercise of the discretion because it would be a circumvention of the regulation. And the other points, and we say there are four principles. I don't need to take your lordship to these cases, but there are four principles we say which come out. First of all, the court's got to determine as a threshold issue whether there are exceptionally strong grounds, which are rare and compelling enough, that would warrant a temporary stay. Secondly, if there are no such grounds, then there's no basis for the court to exercise its case management power under Section 49.3 and CPR 3.12F. Thirdly, and on the other hand, if the court does determine that there do exist exceptionally strong grounds which are rare and compelling enough, which might warrant a stay, then the court does go on to consider whether the grant of a temporary stay is in accordance with the overriding objective. But, lastly, if the case is one where the English court has exclusive jurisdiction under Article 25 of the regulation, and none of the lis pendens provisions in the regulation apply, then it would be inappropriate that there should be a temporary stay for any period which would allow a foreign court to decide key issues, and the authority for that is Standard Chartered, Mr. Justice Flo, as he then was at paragraph 131, or which would prevent the court from exercising its jurisdiction under the regulation, since otherwise the regulation is circumvented. Those are the four principles. And we say the judge went wrong in the following 5 respects. as the judge
Just
himself...
before you do, is there really a third point considering the overriding objective? It seems rather hard to imagine a case where you succeed at stage 1 in showing rare and compelling circumstances and exceptionally strong grounds, in which the overriding consideration of the overriding objective would not lead to the same conclusion.
I agree. I agree with that, with respect, my lord. But the fact is, one still got to consider it, because CPR 1.2 mandates that when the court exercises any power given to it under the rules, it's got to do so in accordance with the overriding objective. So, as a formality, the court's got to consider it. But I agree wholeheartedly with the Lord that it would be a very rare case, I can use that adjective again in a different context, it would be a very rare case if the court, having found what your lordship has just said, it then held that for some reason the overriding objective didn't warrant it. I mean, one doesn't need to engage in counterfactuals, but in an ordinary case, your lordship's right.
So Sammy, can I tell you why I rather think, I may say so, agree with my lord, and I have a problem with the way you've put it, but I don't think it comes to anything in the end, is this idea of a threshold principle.
Exactly.
I don't like that, I've got to tell you.
That's not what Lord Bingham was seeking to set up, a gateway. He was, as I understand it, saying that when you're exercising the discretion which is conferred by the rules, you approach it in this manner. But I don't think we're any of us very taken by the idea of breaking it down into 4 stages or whatever it is.
Well, I hear what your lordship said. The point that we're making is this: the judge, in his judgment, when he begins to consider a stay, says, I start with the overriding objective. And with respect, that's not the starting point. The starting point is to examine, are there rare and compelling circumstances, or rare and compelling enough and exceptionally strong grounds, by reference to all the factors which are normally considered by judges in the business of...
Yes, well, I think you're trying to make the same point in a different way. But the question is whether the judge oriented himself correctly by the couple of paragraphs in which he refers to the overriding objective and rare and compelling circumstances. I don't think we're going to get very enthused about the order in which he approaches it and so forth. The question was whether in substance he did or he didn't, and you may be right, he didn't, approach it with a sufficiently rigorous test in mind.
Well, my lord, I hear what your lordship say. On that basis, let me then recalibrate the submission. And the recalibrated submission is this: that is exactly what he did not do. He did not, for example, take account of the fact that a stay was unavailable under any of the lis pendens provisions. He didn't pay sufficient regard at all to the exclusive jurisdiction clause in the agreements. And the way the judge expressed himself in paragraph 198 shows that he doesn't pay regard to it, because his lordship says, if the claim, he says, I don't think that a stay would fail to give them their proper weight. If the claims under the contract are to be tried at all, they should be tried in England. But that's after the event. The whole issue is what's the effect of the exclusive jurisdiction clauses in the context of whether a stay should be ordered in the first place. What his lordship does is say, well, I think there should be a stay. It doesn't matter, because if and when the stay is lifted, that's when the exclusive jurisdiction clauses bite. So that's where we say, in substance, he went wrong. And we also say that his decision was one which impermissibly took account of forum non-convenience factors, because to hold that the real adversary, an appropriate respondent to the claims, isn't the respondent, but rather the OPJ, and for that reason to halt the progress of the action here, is ultimately to prefer the Vatican Criminal Court as the arbiter of key issues which ought to be decided by our courts. And indeed, that's hardly surprising that the judge perhaps was driven down that route, because that's what was urged on him by the respondent in their submissions and their evidence. And let me just briefly, I'm coming to the end, show your lordships, please, at supplemental bundle, tab 17.
Just before you do, what are the key issues which ought to be decided?
Well,
not criminal liability.
No, of course, no. The key issues, for example, relate to give you an example, your lordship case, the valuation of the property, whether the declarations which the judge has held are justiciable should be granted or not. These are key issues which relate to the transaction. And effectively, it's being hived off, that's the practical effect. Some of these key issues are being hived off to the Vatican Criminal Court.
Well, the valuation of the property is something which the Vatican Criminal Court has probably got to decide if the criminal proceedings
One would expect
continue.
so. One would expect so.
I mean, your point, I suppose, is that well, the ultimate key issue is whether there is a claim for civil compensation.
Yes.
But that may involve issues, such as the valuation of the property, having to be decided both here and there.
Yes, but they should be decided here because of the English exclusive jurisdiction clause. We have a justiciable claim which has passed the Article 25 test, which has survived summary judgment, which disclosed serious issues, and before the English court could grant those declarations, it's got to determine whether it should. And whether it should grant those declarations. For example, did Mr. Perlasca have authority? Did the claimants act bona fide? These are key issues which the English court are seized with now because of the judge's decision on jurisdiction, and which the stay is preventing this court from ruling on. In the meantime, the Vatican court is going to be probably dealing with those issues. So a foreign court is determining issues, whilst the English court is hamstrung by the stay.
Isn't paragraph 197 the real nub of it?
Well, my Lord, that is, that's why, yes.
Well, that's what's rare and compelling.
Well, that,
according to the judge.
According to the judge,
yes.
That's what he said.
That's what he
Yes.
hung his hat on.
Yes, and that's why we started with ground 4.
Yes, so that's what it all comes back to in the end.
Well, it does. And
Either that's a conclusion he was entitled to reach, or it's not.
On that ground, yes. I'm not giving up my other grounds.
No, yeah.
But your Lordship is right. I say that's why we started with ground 4. My Lords, and I just want you to show...
You've been talking about how one frames it, how one frames the legal test, but in the end, it's a question of whether that's sustainable.
I hear what your Lordship says. I'm not surrendering my other grounds because we've got permission to appeal on them. But I made my submissions. I'm not going to repeat the submissions. But I'm not disagreeing with the substance of your Lordship's point. Lord, can I just show you, in the last 45 seconds or so, at, please, tab 17 in the supplemental bundle. It's at page 274. And in paragraph 74 of Mr. Walsh's statement, and it's 7 lines up from the bottom, I respectfully contend that the question of whether the conduct of Mr. Minchele and his companies in relation to these matters can be declared by any court to be in good faith could never be determined until the facts and matters set out in the indictment are tried before the Vatican City State Court. That is, with respect, a heresy. And then at paragraph 75, Mr. Walsh goes on at the bottom of 274, I respectfully can't see how this court is going to be able to determine these declarations while the trial over the matters and more is simultaneously going ahead in the Vatican City State. Another heresy. You have the exclusive jurisdiction clause. Any trial in England, he goes on, would simply involve a duplication of the issues raised in the current trial in the Vatican City Court regarding the London property, the nature of Mr. Minchele, and the other claimants' dealings with the Secretariat. Pausing there, other claimants, and it does bear repetition, have got no involvement in the Vatican City State Court, and that is a third heresy. So, my Lord, for all those reasons, we respectfully submit that this was a decision of the judge which was wrong, either because he applied the wrong legal principles, he took into account irrelevant matters, failed to take into account relevant matters, and was certainly wrong on neutrality, and was so plainly wrong as to be regarded as falling outside the discretion, the generous ambit of discretion even afforded to a judge. That leaves ground 5. I've already said I'm not going to trouble your lordships orally on those. Unless we can assist your lordships further. Those are our submissions.
And in relation to the point that we discussed earlier on, which is whether there would ever come a point in which this court would have a discretion to exercise. That's a matter on which you'd have a right of reply if we were persuaded otherwise. By the respondents.
Yes, but it's not been said so far.
No, exactly.
Yes.
I just mentioned it for completeness.
Obliged.
Stephen? Thank you very much. Yes, Mr. Hollander.
Your Lordship pleases. Because of the way the learned friend has dealt with this, it's important in my submission to understand in some detail how the judge got to where he did. And the case had morphed very significantly from where it started. It's one of the problems facing the judge. He goes through this, we needn't turn it up, from paragraph 41 onwards. Originally, there was an application for leave to serve out at common law because the claimants had not appreciated Article 25 was relevant. And there was a purported service of the claim form set aside because they'd served that wrongly. Just 2 weeks before the hearing in October 2021, the claimants appreciated Article 25 was relevant and sought to change tack. There was a further problem because the claim form had to be served with Form N510, which is a certification. They haven't done that. And the result of all that, there were applications for retrospective permission, relief from sanctions. It also meant that much of the evidence which had been served was actually focused on the wrong targets in the light of what happened. So what the judge sought to do, he first of all sought, because there was, I think at that time, as I understand, the skeletons were a little bit ships that passed in the night. He sought to define the issues at the start and identify what he thought the issues were. Many of those most of them are no longer relevant in the light of what's happened. And I think we just need to look at how he dealt with this in the judgment. The key issue, he identified 6 issues. And if you look at paragraph 129 of the judgment, which is at core 118, he identified 5 questions on what he referred to as issue 3, should the claims be dismissed at this stage, and identified 5 submissions put forward by the defendants. And he found against the defendants on 4 of the 5, but in their favour on issue 2. He then deals with those at 165 to 179, starting at page 128 of the bundle.
So the no useful purpose is the no utility.
No utility. That's it. He then reaches his conclusions on that at 178 and 179 on page 131, which is that as matters stand at the moment, there is no real prospect of the claim succeeding because there is no utility or no useful purpose in the declaration sought. And it was in the light of that finding that he then considered at 192 onwards on page 134 the stay. And I think 194 is just worth looking at on page 134. I've already made clear that in my view this claim cannot succeed while circumstances remain as they are. I've decided not to grant summary judgment only because circumstances might reasonably anticipate change between now and trial. These seem to make a stay, these findings make a stay desirable. So, in effect, whilst the focus on my learned friend submissions is to complain about the stay was an order effectively for the benefit of the claimants. Because what he was saying was, as things stand, there is no prospect of this claim succeeding, but I won't give summary judgment because I can see that things are fast moving, things may change and so forth. So actually, the curiosity about my learned friend's focus on the stay is that this was an order for the benefit, effectively, of the claimants. Now, and there is no part of my learned friend's submissions seeks to go into detail about the utility point, which is key, and which is the whole premise of which the judge's judgment.
But the judge's decision on utility, I think we see at 176 to 178.
That's right.
Where he says, where he pins it to the fact that it's not the defendant who is primarily interested in the declarations, but the OPJ.
Well, we have to go through.
So for the judge on this, in this case, utility, no useful purpose is key, but it has to be understood as meaning because of the defendant's neutrality.
Well,
Is that fair?
Your Lordship puts it that way, and that's the way my learned friend has been putting it. The word neutrality, which, as my Lord Jackson said, is not a term of art, needs to be seen in its proper context in this case. And we need to look and see, because the judge, there's a lot in this judgment, and we need to see with reference. Because, for example, you've not even been shown the criminal proceedings. And they're quite important, if I may say so. And you need to see this in context, because, as to why the judge got to where he did. But your Lordship is right in terms of the point. That's the point I have to focus on. I've already focused on the slightly erratic, perhaps, way in which the proceedings were started. The claim was premised on a misunderstanding. Can I just pick up your Lordships? There are a couple of occasions earlier where your Lordships made the same mistake that I've made lots of times, which is referred to Italy. This has got nothing to do with Italy. Vatican, of course, is a separate state, separate system of law. I'm sorry I've done exactly the same thing. It's terribly easy to do. I just wanted to pick that up because I suspect it will cause a certain amount of excitement if your Lordships were to do that. Sorry. If the judgment at paragraphs 2 onwards, right at the start, which is page 81 of the core bundle, refers to the Secretariat. And there is no issue, and the learned friend was very clear to confirm, I think, when my Lord Justice Peter Jackson made a comment, as there's no issue that the defendants are entirely separate from the...
I recant.
I'm sorry, I don't mean to...
Well, it wasn't a...
No, I know.
A helpful intervention, but
Please,
it's not a significant part of it.
Sorry, but that is... it is important because, paragraphs 2, 3, and 6 are the passages in the judgment which are not challenged, which make that point. But the claimants had made that same mistake through, and it pervaded these proceedings, that they had confused the two. We can see this, for example, if you go to the back of the core bundle at page 228 in the claim, starts at 227, and having correctly at 228 defined the Holy See as having referred to the defendants, the Secretariat, but defined them as the Holy See, when you get to paragraph 31, which is the meat of the claim, at 241, you will see that the claimants have done exactly the same thing and have confused, having defined the Holy See as the Secretariat, they refer to the Holy See having made a request for judicial assistance in criminal proceedings to the Swiss authorities, which of course is entirely wrong, because it was the OPJ that made that request to the Swiss authorities. So what they were saying was that it was the Secretariat who had brought and confused that. The basis of which they're saying that allegations were made by the Holy See were certain unspecified press cuttings and the request for judicial assistance in the proceedings. And they say by the Swiss proceedings, by paragraph 32 on 242, it's by reason of those matters a dispute has arisen. And 33, the Holy See has not particularised any claims it may bring, can't identify facts it will rely to refute. So that's the basis in the particulars of claim. Then in the evidence, there are a whole variety of matters where they make the same mistake. For example, Supplemental Bundle 157. This is Mr. Wood, the claimant's solicitor, and having started at paragraph 44 on page 156 to explain why they say a dispute has arisen between the parties, and saying that they haven't been conceded. At 46, 45 they rely on press reports. 46 they rely upon the criminal investigation. So Mr. Wood again is putting forward evidence which is making the same confusion between the defendant and the OPJ. He then goes on to talk in paragraph 48 onwards to a judgment of an English judge in criminal proceedings, and relies upon criticisms and observations, this is 48, fourth line, about the OPJ, and then in 49 to 50, he again is confusing the OPJ and the Secretariat, and relying upon the position of the OPJ against the Secretariat, as it were. There is a further passage, I can just show you briefly, at page 234 of the same bundle, where Monsignor Paniagua, I'm going to call him Monsignor Carlos for ease, if I may, he puts in evidence on behalf of the defendants. And at page 234, in paragraph 42 and 43, he draws attention to all the points where the claimants, Mr. Wood in particular, have confused and conflated the OPJ and the defendant.
So where does this go? Because I could understand us having to go through all this if the judge had been misled and had conflated them. But you seem to have the benefit of a judgment in which the judge resolutely did not do that.
The judge didn't.
Yes,
but
so
when he's looking at utility of the proceedings, and I'm going to show you, Lordship, in a moment, the circumstances in which we see the circumstances leading up to the commencement of the claims, which is all part of the history which the judge relies upon in terms of utility. It starts off because he does make findings in terms of what the purpose of the proceedings was, and I'll show you that in due course. So there are a series of misunderstandings, if I may. I'll come back to the start of the proceedings in a moment. The particulars of claim rely and refer in the negative declarations they seek on two contractual documents, each of which has an exclusive jurisdiction clause. And the first of those is the Framework Agreement, 22nd of November 2018. The second of those is the SPA, a Sale and Purchase Agreement, which is dated 3rd of December 2018. Those are the two agreements that have exclusive jurisdiction clauses in favour of England. There is also a third document, which is confusingly called the Share Purchase Agreement, dated 28th of November 2018, which is not relied on by the claimants at all. And if you can look at the judgment at paragraph 17, the judgment in paragraph 17, page 87, the judge referring to a comfort letter, which isn't relevant for present purposes, conferring authority on Monsignor Pelasca to sign the SPA, it refers to a contract called the Share Purchase Agreement, which And then he says at the end of that paragraph, that's plainly a reference to another SPA in the bundles for the court, which matches the description of not the SPA as defined in the framework agreement and the particulars of the claim. So the two documents that are relevant, the SPA and the framework agreement. When one looks at the indictments, which are in the fresh evidence bundle, they are, my Lord Justice Mayles is right, that they are substantially the same as they were in their previous form. But I think one does need to look at them. Learned Friend never took you to them, and they are really quite important, if I may say so, because if you look, starting, we can take them quite quickly. They start at page 3 of the fresh evidence bundle. So what had happened was that there was an initial indictment that was set aside, sent back, doesn't really matter exactly what, and reissued. And if you look at page 3, we see the charges which are being brought under the indictment. Now, there are 11 charges in total against, I think, 13. There are, I think, 13 defendants. One of them's got nothing to do with Mr. Minchoni at all. And of the 10, 8 of them have got nothing to do with either the framework agreement or the SPA. So we can just see, so essentially what is being said is that these 13 people conspired from 2014 onwards to defraud, that's the indictment, to defraud the Vatican in a variety of different respects, which to some extent may be related. So if you look, for example, at the first charge, and you can see this is all about events in 2014, and you can see right at the end, so if you look at the end of this charge is on the top of page 4, and the date of the events are June to July 2014. So this is all concerned with things that happened 4 years before. So essentially, it's a fraud claim involving the proposed acquisition by the Secretariat of shares in Athena at an excess value in 2014, so 4 years before the relevant agreements. The next one, and I'll take these fairly quickly, is embezzlement. It's 2014 to 2018. It's a 200 million claim, so it's got dollars. So I mean, it's not, that's 2014 to 2018. The third one on page 5, abuse of office in improving investment in Athena in 2014. And you can see the date at the end, July 2014. The fourth one is embezzlement in the subscription and dissipation of monies in Athena between 2014 and 2018. The fifth one, E, on page 7, misappropriation of monies in a company in April 2018. That's still some months before the two relevant agreements. The E is, to an extent at least, concerned with the framework agreement. That's the first of the two. It's an embezzlement claim, and it's an embezzlement claim under Vatican law, which has a relevant. It's procuring the entering into of the framework agreement without reference to feasibility or economic benefit. It goes to the circumstance. That's E. Sorry, that's F. G is all about money laundering in relation to monies. It's 185.8 million euros investment. That's different. That's between 2012 and 2014. H has got nothing to do with it. Money laundering of 18 million euros between 2017 and 2018. I is money laundering in other companies, 9.1 million in 2017. And J is concerned with the framework agreement indirectly, so that's the second one, which is concerned with concealing or disguising the real origin and nature of the sum of 40 million paid to accounts. So that has a relationship with the framework agreement indirectly. And K is not against Mr. Minchoni. That's a bribery allegation against somebody else. And there are a variety of defendants. So you can see that this indictment, I mean, it is effectively, it is a major criminal investigation in the Vatican which has gone on internationally since 2019, involves Swiss authorities, freeze of Mr. Mincioni's Swiss assets and letters rogatory. It's concerned with the conduct of a large number of individuals, some formally appointed by the Vatican over a number of years, and allegations that they committed a series of frauds from, I think, 2012, I was going to say 2014, I think one of them was 2012, onwards. And the suggestion that this is all, that this can all be determined by the value, by evaluation of the property. I mean, this is the allegation, right or wrong, is of a major international conspiracy over 7 years involving 13 different people, of which the SPA doesn't get a mention once, and the framework agreement, as I've said, is indirectly irrelevant to 2 of those charges. So that is the indictment. And as I said, the suggestion that a friend was putting forward that, well, you can sort all the London proceedings out by evaluation of the property, with respect, is just simply wrong. Now, so that's the indictment and that's the proceedings. And I think, with respect, your lordships may have got an entirely wrong perception of what these proceedings by the OPJ are all about. They really are not just all about the framework agreement. Anyway, so what the judge concluded in terms of the position of the Secretariat, he deals with this at paragraph at S99, supplemental. I got the wrong. 2004. Sorry. 99. Paragraph 60. So he then deals with the question, paragraph 60, page 99 of the core bundle. So he deals with the question of neutrality, as it's referred to. I would suggest that's probably an unhelpful expression, but we'll see where we get to in respect to that. Essentially, what Mr. McParland told the judge was that it looks from the investigation as though the Secretary of State has been the victim of a serious fraud and would obviously have to be investigated. Well, with great respect, that's obviously right. It looks as though, whether it is or not, who knows, and referred to the evidence as to reasons to suspect there had been a fraud. But given there are 13 defendants and 10 different charges, to say that there was a fraud really does not get us into the framework agreement at all. The answer to, is there a fraud, even if one said it looks definitely as though there's a fraud, which isn't what they've been saying, which defendant, which bit, which part of it, which charges, I mean, it's all completely open. So
was the judge wrong at paragraph 23?
Well, that's the letters rogatory. So we're talking, the letters rogatory...
Well, the essence of the allegations under investigation appears to be that the transaction, which we know means the framework in the SPA, involves substantial overpayment by the defendant for its interest in the property.
He's focusing on the letters rogatory. I mean, your lordships can see the indictment. I mean, it goes on for 7 years. It's the vast majority, much of it anyway, is all about 2012 onwards.
But let's suppose one proceeds on a firm footing with what you're telling us,
yes.
And that this is just, the property is just one part of the picture. And it's a large part, a small part, or whatever it is, it's a part of the picture, but not the whole of the picture. Why would that be a reason for stopping the proceedings here?
Well, when I think one has to break down the various steps on utility, that's the first step. Is actually
why would it not be a justiciable issue if it's?
Well, it may be justiciable, but it would not. The judge concluded it would not fulfil the legal test.
Yes.
There was no prospect.
I understand that, but let's suppose you are right to say that the indictment goes much further than simply a complaint about fraudulent overpayment.
Yeah.
What difference would that make? That what wasn't really what the reason that the judge gave for staying the proceedings.
I'm sorry. He set out the circumstances And again, my learned friend has sought to detach bits of the judgment from the whole.
So I'm giving you a chance to deal
Yeah, no, I know.
the counter position, which is where that you're seeking to build another pillar for the judgment.
No. Well, I'm seeking to uphold the utility point, which is the judge's finding.
But why the judge didn't make a no utility finding on the basis that this was just a small part of the overall picture?
No, the judge went to look at the purpose of the proceedings being brought.
Yes,
in.
but I'm very well willing to be shown that I've not got this clear in my mind. But at the moment, I don't understand the judge to have found in your favour on the basis of the argument that you're now making.
Well, with respect, he's gone to look, and this is the paragraph in the 70s, where he looks at the circumstances of bringing the action and what the purpose is.
But where is the high point in the judgment of saying one of the reasons that there's no point in these proceedings is that they just represent a small part of what's going to be decided in the Vatican?
Well, if you look at 77 and 78.
Right.
77, I need to come back to these because I do need to show you, Lordships, them in their proper context.
Well, 77 is to do with interference with criminal proceedings.
But what he's saying is what the purpose of the proceedings, so Mr. Mincioni, is, and why he's brought them. And that's the context of utility. In 78, and I know he's deciding along the way the question of whether they're an interference, but they are relevant, they're highly material to utility. Let me, if I may, if your Lordship would bear with, I'm so sorry.
I just wanted to share my concern about this particular point, but please continue.
I will deal with you. The judge has concluded that the Secretariat or the Secretariat's position has been, as I've indicated. My learned friend then relies so it's showing that they've taken a position on the party civili or civili, I would pronounce it, and says, well, that shows that they have taken a position. Now, the judge explains that at 67 to 74. So this is effectively a Vatican law statutory cause of action, as he finds it, which is whereby ancillary to criminal proceedings, a party or an individual can bring an ancillary action on the back of having been the victim of fraud. It's a statutory cause of action under the Vatican Code, which is not replicated because in English law you don't have that cause of action. And what he's said is that he's referred at 67 onwards to the fact that the defendant has sought to be a party civili in those proceedings. And then he refers to Mr. Walsh's evidence about that. And then at 70, he concludes that by seeking to do that, he's not taken a position that the charges are true, but merely asserted a right to compensation in the event they're proved. So essentially what he's doing, what the Secretariat of Defendants have done, is they have done exactly that. It is ancillary to the criminal proceedings, whereby if the criminal proceedings, if and to the extent the criminal proceedings succeed, they seek to take advantage of that statutory cause of action in their favour, against, at the moment, any or all of the 13 defendants who are found to have been liable, and to that extent, in the Vatican criminal proceedings. So it's not a cause of action that is or could be replicated in this country. It's not based on contract, it's based on, effectively, the Vatican statute. So that is the circumstances, and then he explains that...
You're not saying, are you, that if there is fraudulent conduct in relation to the London property, that there would not be a cause of action here?
Well, it depends on exactly... What I'm saying is that this is a statutory cause of action. There may be causes of action, of course, in English law, depending on circumstances. But this is this is a broader, if you like, statutory, or maybe broad, maybe narrow. It's a different statutory cause of action, which is based on the fact that a party has suffered loss by the criminal conduct.
But
that is
you refers to paragraph 70, but the finding at the end of that the defendant has not taken a position, if that's what it is, a finding, is expressly said to be based on the words of the document. Well, Mr. Samek says, read the document, and there is a taking of position.
Well, there's a taking of position in the sense. I mean, he goes on in 72 to explain that the provisions of the Vatican law were exhibited, and he points out that civil proceedings are barred or stayed while the case proceeds. As a result, an alleged victim has a strong incentive to join because there can't be a civil proceedings at the time, and there's no suggestion in materials that it's required to take a partisan position on whether the crime took place. So, I mean, that's the finding based on Mr. Walsh's evidence, and he then in 73 says it remains a contingent claim which will be advanced if and when the relevant facts are established in the criminal case. As I understand it, and I don't think anyone suggested the contrary, if the criminal proceedings do not succeed, then the party civil fails. So it's ancillary to the criminal proceedings, and therefore the effect of it, although it is a claim for an indemnity, because it is parasitic, if you like, on the criminal proceedings, it is effectively saying, if the criminal proceedings are found, then I want my compensation under the Vatican law against whichever defendants or against, in respect of whichever matters, the criminal proceedings are determined in a way that affects me. That's effect, as I understand it, what is being said and what is, we would submit, correct. So that's the context in which he is saying that. And of course, there are, I mean, parties civil to the whole thing, and we've seen the position in terms of lots of charges, lots of defendants, and there isn't an English law equivalent in the same way, because you can't turn up in the criminal courts here and simply say, if the criminal court finds the defendant guilty, then we want compensation based on the findings of the criminal court. It doesn't work in the same way here. So that is the basis. Now, on which the judge so concluded, but he then considered the circumstances of the proceedings being brought and the interrelationship between that and the proceedings in the Vatican. And we can pick this up at S276, because he's made findings about the purpose of Mr. Mincioni bringing proceedings. So if we pick up at S276,
Is S supplemental?
yeah, I'm so sorry, yes. At paragraph 79, Mr. Walsh. So December 2019, Mincioni puts in his first, paragraph 79, his first defence. 80 shows he was about to be questioned in May 2020. Lawyers confirmed he was available for questioning, and then and dates were suggested for him being questioned. 81, he confirmed he was available to attend a hearing in Rome on the 19th of June. He did not travel, which he said was a family emergency. His lawyer said he's willing to attend at a future date, and Mr. Walsh then refers to the statement, his second defence brief, which was 19th of June 2020, and that was on the 16th of June. He had commenced the English proceedings, these proceedings, and he then at the end of the second defence brief on the 19th, he having not turned up to interview, he, paragraph 86, informed the prosecution that Mincioni and the other claimants that had issued proceedings in England. Finally, we need to communicate, this is paragraph 86, that Athena and others and Mincioni have been forced to take action in the High Court of Justice with the preliminary statement about to be notified to the defendant, the Secretariat of State. The aim of the action is to obtain a declaratory relief judgment which will achieve, among other things, the recognition and confirmation of the rights and obligations of each of the parties based on the framework agreement, the SPA, the transfer agreement, the power of attorney, and their validity and the binding nature on the parties. So, having not turned up for questioning, he then puts in his second version of his defence 3 days after commencing proceedings in England, where he refers to the existence of his proceedings in England, and that is why the judge then says at 77. So he starts in terms of 75. The subjective motivation. This is core 104. So this is the judgment. I'm sorry, I should have made that clear. Core 104, judgment paragraph 75. So there is a question as to the subjective motivation of the claimants of bringing these proceedings, and refers to a variety of matters, where Mincioni asserts that, at the end of paragraph 75, Mincioni asserts that this type of prejudice will continue so long as the defendant, and I've drawn attention already to the area of confusion between the defendant and the OPJ, continues to dispute the lawfulness and validity of the transaction. The judge says, in one sense, I agree, I accept that. I accept he wishes to contest, and that one reason why he wishes to do that is to mitigate the kind of disadvantages he refers to. In another sense, I don't. Since I found the defendant has adopted a neutral stance, I don't accept it's any challenge to the lawfulness of the transaction by the defendant that has led to the issues faced by the claimants. Nor do I accept that Mr. Mincioni believes otherwise. Just pausing there, it plainly isn't anything which the defendant has done which has led to these proceedings. Why on earth would it have been? The criminal proceedings, which have been going on since late 2019, have been all over the world press and will continue in the Vatican. I've explained, this is before actually they sought to become a party civil in any event, that Mr. Mincioni was saying this. And I've already shown you the confusion in the pleadings and his evidence between the OPJ and the Secretariat. So how is it that it could be said that any challenge by the defendant has led to the issues faced by the claimants? Nor do I accept Mr. Mincioni believes otherwise. I'd suggest that's obvious. It's obvious from the public pronouncements of relevant parties. The source of the commentary is the undisputed fact the OPJ has been investigating Mincioni and others and has brought or wishes to bring serious charges against him and then, in the light of that, he considers at 77 whether there's an interference with the criminal proceedings. And arrives the question whether he is seeking to interfere. The defendant's case is that he wants to be able to say to the criminal court that this court is investigating the transaction. Well, of course, that's... And
I mean, in short, he says that's what Mr. Mincioni wants to do, but he finds it's not going to work.
No, I see that. But then he looks, in the light of it's not going to work, we come to utility in the circumstances where, what is the point of these proceedings in circumstances where it's the OPJ proceedings which are the ones that are going to focus on it. We've got all these charges, and what he goes on to say in 77 is that, about 7 lines from the end, well, let me start with Mr. Samek, about 7 lines from the start of 77. Mr. Samek said that the relevance of his paragraph, I quoted, was to show that the OPJ, that Mincioni truly believed in his defence, and he was having the matters resolved by the court, chosen by the parties to the contractual documents. This response was consistent with the defendant's case that at least one subjective purpose which the claimants bring these proceedings is to permit Mincioni to tell the Vatican criminal authorities the court is considering issues at the heart of the criminal investigation. I find it's indeed part of the claimant's intention that the fact of these proceedings, and no doubt any favourable judgment, should be the subject of submissions to the investigator and the criminal court in the Vatican State. So that is, and then he goes on in 78 to see, well, it won't make any difference. So what he's doing is he's identifying the purpose for Mincioni of these proceedings, and then saying in 78, given it's the OPJ conducting the criminal investigation, actually what the English court does isn't going to achieve that purpose at all. In 78, he says, I can't see, third line, how any declaratory rulings of this honourable court would assist either the OPJ in the conduct of their criminal investigation or the Vatican system in any criminal trial of these matters. They wouldn't assist a criminal investigator, prosecutor or court in the Vatican State, and the evidence will have no effect on the criminal process. And then he concludes in 78, nothing in this proceedings is likely to have any actual significant influence on the Vatican State criminal proceedings. So the reason I've shown your lordships that is, although in part this is for the purpose of rejecting the argument that it will be these proceedings will be an interference with the Vatican proceedings, which the judge rejected, but also what he's saying is, when you look at the reason why these proceedings have been brought, on the one hand, it's for an ineffective purpose, if you like, to try and get them before and provide some basis to the Vatican. But actually, that's not going to have any purpose. So that's the reason that he has sought to do that and to deal with that, because again, that goes to and when you look at what Mincioni himself said, which provide the basis of that, that was at Supplementary Bundle 187. I'm sorry to keep jumping around. And effectively, he explains why why these proceedings are being brought at Supplementary 187, and these are the matters that the judge is referring to. He's complaining about libelous media reports, paragraph 180. So this is Supplementary 187. Complaining about libelous media reports. 188, unjustified regulatory queries, difficulties with joining associations, purpose of this action. So in the light of all that, it's plain the Secretariat disputes lawfulness and validity of the transaction and the documents. Consequence led to the prejudice suffered by the claimants as referred to above. Now, again, just pauses there a moment. He said, he's essentially justifying the action on the basis that he needs to bring this in order, as it were, to clear his name. And what he's saying, again confusing the Secretariat and the OPJ, that the challenging the agreements has fueled, directly or indirectly, the prejudice in unjustified regulatory queries, libelous reports, and so on. And then he goes on to say that in 82, it's right that the court should be able to rule. And at 83 to 85, he explains the purpose. He refutes an ulterior motive in 83. Nonsense to suggest I'm trying to interfere with a criminal investigation. The corporate claimants and I declarations that track the terms of contractual documents. And then 85, the declarations sought evident value to me, in addition to the corporate claimants. And given I've been publicly associated with the transaction along the corporate claimants, given the foregoing, it's obvious I'm directly interested in the declarations sought. Now, so that has to be seen in the light of what the judge is saying in these paragraphs. He's saying, look, he's claiming that, and again, it's in the context of a measure of confusion between Secretariat and OPJ. He's bringing these declarations, as it were, to clear his name, but that's not going to achieve anything.
So the judge might have said there's no utility in these proceedings because they're not going to achieve the object which the Mincioni wants of interfering with the Vatican proceedings.
Well, he's put it
but
one
he says it. Sorry, he says that won't work. But he puts utility in different terms altogether, doesn't he, when he comes to deal with that?
But these are the findings, which are. That's why one needs to see this in context, because he's actually explaining why this action is being brought, and is saying effectively it's for an ineffective purpose.
Well, all of this might be of interest, it seems to me, if this was an application to strike out for an abusive process. But that's not what this is about. I follow through the argument, but let's suppose one is considering the purpose, or as otherwise described, the subjective purpose of the person bringing the suit.
Yes.
People can sue for many sorts of reasons, some of them pretty bad ones. I just don't understand really what that's got to do with it. Some people are extremely thick-skinned, some people are extremely thin-skinned, other people have different views, and people are entitled to bring legitimate claims, legitimate in terms of having a legal foundation, even if they are going to lose them, even if they might have been better advised not to bring them. So I don't really understand why all this attention on the claimant's purpose is likely to lead to anything. Of course, if it was an improper purpose that was going to lead to striking out, that'd be one thing. But otherwise, what's this got to do?
That's not the test on negative declarations. Negative declarations are a particular animal where there is law on the circumstances where the court will grant them.
But it might refuse a declaration
but the judges,
on examination of the facts at trial.
But the judge is saying, the judge's conclusion is that on things as they stand at the moment, there is no real prospect of those negative declarations being granted, because they would not be found under the law on negative declarations to serve a useful purpose within the confines. And I'll show you, Lordship, this afternoon. There's a nice summary of the circumstances in which the court will grant negative declarations. So it's not like a claim for damages, and the fact that you're bringing a claim for damages, unless, as your Lordship says, it's an abusive process, you just carry on with it. And exactly why.
Right. Well, you'll show us the point at which the judge makes this very point.
Well, the key in the judgment is 178 to 17. If you look, for example, at 176 on page 131, he ties in what he's already said, because it's at this stage the findings I have. This is page 131 of the core bundle. It's at this stage the findings I've made in relation to the defendant's central argument become important. The central argument was the purpose of the proceedings was actually to interfere with the Vatican. And that is the lead-in to what he says in 176 to 179. So what he's doing is actually saying, look, in the light of what I've said already, that's what the judge is doing here. So that's why it's important in my submission. That's exactly what the judge is saying, that I've looked at the circumstances in which this action is being brought. So then one says, one makes, one says, well, why? What is the purpose of this action? And the judge has found it would not affect a criminal investigation.
The central argument is what he defines at paragraph 56, yes, which is that the only relevant or real dispute is between the claimants and the OPJ.
Yes.
Which is different from what you just said. He goes on to refer to the purpose of the argument, the purpose of the proceedings, but the central argument is that you've got the wrong defendant.
But one's got to see that in the context of why these proceedings are being brought. So one asks this rhetorically: if the criminal proceedings fail, is there any purpose in these proceedings? Answer: no, because there's nothing that has happened to indicate that the Secretariat will bring a claim.
Sorry, can I just reverse out of that? Let's suppose, for some reason, the Vatican proceedings ended.
Yes.
Without findings of culpability. Why in that situation would it not be open to somebody in Mr. Minceni's position to pursue his proceedings here?
Well, that's exactly the judge's point.
Well, I know, but that's posited on the basis that he's right. I'm asking you why he shouldn't be able. I mean, after all that's happened,
Yes.
he may think that he's capable of obtaining a favourable outcome, and that may be of value to him. What's wrong with that?
But again, it's a negative declaration, and the court won't grant it unless there is a utility in it. Now, if there is this is against the context of the current utility, is for the purpose, is as the judge has indicated. If there comes to a stage where there is a different utility, that may be a change of circumstances, and the end of the Vatican proceedings might be that. Again, if he loses the Vatican proceedings and he's found criminally liable, although that's not likely to make it necessary to bring proceedings in England, it's unlikely that that's going to be helpful either. I don't know.
Is that a convenient moment?
If that's convenient to...
I mean, it strikes me that, although you must take your own proper course, it strikes me that we're capable of dealing with the remainder of the appeal during the course of the day.
That's right.
Probably if you're spared unnecessary interruptions.
No, I encourage interruptions.
Because certainly I think that if we could aim to allow Mr. Samek 20 minutes or thereabouts in reply, we should be able to. Thank you very much.